My name is Joshua Jones, Assistant U.S. Attorney. I've been with the U.S. Attorney's Office since April 2015. I practice in the areas of, obviously, bankruptcy, but I also do financial litigation, general civil litigation, and violent crime. My colleague Shane started with the office in October 2020, first in the OSADEF division. I'm not going to try to tell you or explain what that acronym stands for, but it's essentially the high or significant drug and gang unit. And then he moved to the better of our units, the civil division. Am I right? Am I right? That's true. In 2021. Shane practices in the areas of Chapter 13 bankruptcy, but Chapter 13 only. He doesn't get to the fun world of 11s and 12s, et cetera. He also handles Social Security, immigration, financial litigation, and like I said, Chapter 13 is on behalf of the IRS. The purpose of the presentation, obviously, I think everybody knows that the U.S. Attorney's Office made a decision in August of last year to change its policy vis-a-vis dismissals of 13 cases when there is a one or more missing tax returns that fall within the scope of sections 1307 and 1308 of the code. We did this for multiple reasons. First of all, it's our job, for better or for worse, you say for worse, we say for better sometimes, to enforce the laws that Congress writes. We don't always agree with the laws, we don't always like the laws, but we are sworn to enforce the laws as written without prejudice to our own personal feelings. But also, over the last few years, we have seen a significant caseload rise, not only in the bankruptcy context, but elsewhere. But just for purposes of bankruptcy, from fiscal year 2023 to fiscal year 2024, we saw a 100%, exactly 100% increase in the number of IRS referrals in Chapter 13 cases. And you can imagine how that translates into caseloads office-wide. But that increase was putting an extreme strain on our resources and our time. And so with the consent of the then U.S. Attorney and the current civil chief, as well as in consultation with the Department of Justice Tax Division, we implemented the new policy that we announced in August 2024 and started implementing as of January 1st, 2025, which is to seek immediate dismissal under 1307 for any tax return that is missing under 1308. Thus far, the evidence is that it's working, so yay for everybody here. For the past 4 fiscal years, 20 to 24, the Eastern District of Missouri, the U.S. Attorney's Office for the Eastern District of Missouri was #1 in terms of bankruptcy cases handled and opened for the entire 8th Circuit. We are one of the larger U.S. Attorney's offices in the 8th Circuit. We are not the largest. Minneapolis, aka Minnesota, is the largest. Yet we consistently ranked #1. Thus far in fiscal year 2025, we've had 54 bankruptcy referrals, and that doesn't just include 13s, that's 7s, 12s, 11s, which ranks us currently 4th in the 8th Circuit. So we're trending down in terms of numbers, which is great. So hopefully part of the reason is that we're getting fewer and fewer referrals for motions dismissed in 13 cases. And at least anecdotally, I don't have the evidence of how it's working in 13 cases specifically, but anecdotally, I can tell you that I am seeing fewer referrals come across my desk from the IRS, which hopefully means that everybody here and everybody who practices in this area is making changes, and we're all working towards a more efficient process. We're going to talk a little bit about the law behind 1307, 1308. I'm going to say this. We invite questions. Questions, please be nice about them. But we invite questions. We could sit here and yap at you for the next 45 minutes. But more importantly, we want to make sure that we're answering your questions so that we are working collaboratively to resolve this process. Because as my last point on my notes is, we're not here to dismiss. We don't want to dismiss your cases. We don't want your clients to go out of bankruptcy. We want them to have the quote unquote fresh start. We want them to have a reorganization. We don't want to be filing motions to dismiss. We want to be focusing on the bigger issues, like objecting to Spencer-sized plans or responding to your various claims objections. That's what we want to be focusing our time and resources. We don't want to be dismissing these cases. We love Judge Clare and Judge Surratt States and Judge Walsh, but we don't want to be showing up to their confirmation dockets and sitting there all morning, no offense, despite our love for those judges. So we're here to try to help facilitate and continue the good work that's already happened. So this all comes about because of 1308. This is just the Texas statute. I probably don't need to read it, but the bottom line is, for the 4 years prior to the petition date, you are required to file those tax returns. And when I say the 4 years, you got to look to when the tax return or when the tax year ended. Those tax returns are due to the taxing authority. In our case, it's the IRS. No later than the day before the 341 is first scheduled to be held. And I keep emphasizing first schedule, and I will keep emphasizing when it's first scheduled to be held, because if Diana and or her team reschedules it to another date, continues it, holds it open, whatever, doesn't matter. Docket number 6 or 7, it's always document 6 or 7 on the docket is going to indicate the date and time that the 341 meeting is first scheduled. That is your trigger. So just take that date, subtract 1, 1308A tells you your new deadline. So this is a hypothetical of how this works. So debtor SK, anybody? Sorry, SK files Chapter 13 petition June 1st. He was passed due on filing the 2022 and 2023 returns. Diana and her team schedule the 341A meeting of creditors for June 28, 2025. What a great day. That means that SK, my hypothetical debtor, must file that 2022 and 2023 return no later than June 27th, 2025 with the IRS. This is something we want to emphasize. I think we've emphasized it a lot. I'm going to emphasize it again. Shane's going to emphasize it many times. Do not send a tax return to us and think it's filed. It used to be that AUSA or a SALSA would accept the tax returns and we transmit it over the IRS, it's filed, you're done. No longer. We will not accept tax returns. If you email to me, I'm going to delete your email. I'm going to respond to you and say, respectfully, you got to send this to the IRS. I'm going to delete your email. You mail it to me, I'm going to destroy it based on the DOJ's policies regarding security of tax return information. If you send me a tax return and I keep it, there are 1,000 different protocols I have to go through. If I take it outside the building to take it over to the rate building, there are 1,000 more protocols. I don't have the time. I'm down a paralegal who took the deferred resignation. So we only have 2 paralegals left in our office in the civil division. They don't have time. We are not going to be taking referrals. I'm also not going to expose myself to any liability for having that return. So if you send it to me, I'm going to say you have to file it with the return or with the IRS, and then I'm going to destroy it based on DOJ's policies. I'm not going to keep it, I'm not going to retain it, and I'm not going to file for you. So you've got to file it with the IRS, not with DOJ.
All right, so the good news is there's a special provision here, Section 1308B. The short version of 1308B is this, and some respects it shifts the situation from the DOJ to the trustee's office, and I know we got some folks from the trustee's office here, and I'll get to it in a minute, but to reinforce what Josh was saying, we've, I think, lost something like 12 or 13 AUSAs in our office writ large and another 10 or 12 staff, and we're under a hiring freeze, and things are changing. So the idea when we were first looking at all of this is, yes, we need to comport with Congress, but also what does that mean in the practice of bankruptcy? What's going to shift? What's going to change? The big shift would seem to be Section 1308B. It says if a tax return that's required under Section A is not filed before the day before the 341 meeting, The trustee may hold open the meeting for a reasonable time, and that time shall not extend beyond. I'll get to those. But the may portion is beyond us. I don't know when it's yes, when it's no. That's a battle for another day. But worth noting, the trustee may hold it open. And then there's two provisions telling you how long. If for any tax return that is past due as of the day of the filing of the petition, it's 120 days. If it's not past due as of the date of the petition, then it's 120 days or however much time you get under the extension, October extension, if you've requested it, it'll buy you that time. The past due and not past due language is important because it's going to come back. We'll talk about it in a couple slides, but for the mailbox rule, Congress is envisioning the tax returns when you're filing your petition. Some are going to be past due, some are not. In general, prior year's tax return might not. You file in January, your April tax return might not yet be due, and that is what Congress is envisioning here. If you have the year prior, so right now we're in 2025. 2024, you file in January, not past due. If you have the year prior, 2023, past due. And that's going to matter for the mailbox rule. We'll get back to that. All right, so to keep with the hypothetical, SK cannot file his 2022 and 2023 tax returns by June 27th, 2025, and ask the Chapter 13 trustee to hold open the 341 meeting for a reasonable amount of time. Again, because 22 and 23 are past due at the time that you filed your petition, you're going to get the benefit of the 120 days. So Chapter 13 trustee may not hold open that 341 meeting beyond October 26, 2025. So it's important to know how much time you can get. But if you have any questions at all about tax returns, I know a lot of the issues have come up of, well, I was told that my client filed them and H&R Block says so. If you're not sure, hold open the 341 meeting. They should have been already delivered to the IRS the day before. If you have any concern at all, 1308 says, okay, I recognize they're not filed, or maybe they're not filed. Hold open the 341 meeting and make sure that they are. That is my advice. So what happens if you don't? Goes to 1307E, which states, upon the failure of the debtor to file a tax return under section 1308, on request of a party in interest of, or the United States trustee, and after a notice and hearing, here's the big one, the court shall dismiss a case or convert a case under this chapter to a case under chapter 7 of this title, whichever is in the best interest of the creditor. The shall language is what we approached the court with back in August of the traditional policy is, okay, we do extensions, we eventually accept them. As I read the statute, I don't think I have the authority to go past what Congress says, this shall happen, and if it doesn't, this shall be the result. And so this is what really precipitated the change in our policy, which is that starting January 1st, 2025, the U.S. Attorney's Office now seeks immediate dismissal. It's no more, several months of continuances. Judge will try to get the tax returns in. If we file a motion to dismiss, in our opinion, at least, we've already vetted that 1307E applies and that this is a shall. There is no discretion. This must happen. And it frankly doesn't matter what the excuse was. So no more multi-month continuances to get a return filed, and there's no exceptions. Again, if you're not sure, and I would not necessarily take the debtors, I'm not calling debtors liar, but they don't always specifically know. I think we had an issue here recently where I went to H&R Block, but did H&R Block file it that day? Those are two separate questions. If you're not sure, 1308B, take a very hard look at it and err on keeping things open, because it might be that it was filed that day. I went to H&R Block on the day after at the 341 meeting. They sent it to the IRS. The IRS got it the day of that meeting. Okay, but if you didn't hold the 341 meeting open, you've got a problem. So use 1308B.
Can I ask you a question since we're getting stunned silence from the audience?
Go ahead.
Okay. Mr. Blank, let's pretend that even though we have the best trustee and the best trustee staff,
which we do
in the United States of America, which we clearly do. Love you guys. What if the trustee in his or her discretion decides not to hold it open? Is there any other option?
There is.
Oh, there is?
All right, so there's also a part B2 of that. So B1 is going to track the trustee and the trustee's discretion and the limits of the trustee's discretion based on if it's past due or not past due. Part 2, after notice and hearing, an order entered good Lord, I cannot read. After notice and a hearing, an order entered before the tolling of any applicable filing period determined under paragraph 1, the trustees section, if the debtor demonstrates, here's an important part, by a preponderance of the evidence, that the failure to file a return as required under paragraph 1, here's the second big part, is attributable to circumstances beyond the control of the debtor. The court, again it's discretionary, may extend the filing period established by the trustee under paragraph 1 for a period of not more than 30 days for returns described in 1A, which is the past due, or a period not to extend after the applicable extended due date for a return as described in 1B, which is the automatic extension if you requested it. So you do have potential relief. There is a burden. It is a preponderance of the evidence standard, and it is beyond the control of the debtor. So understand that when you're asking the court for relief.
So when we were meeting for this, first of all, I would suggest that if you are trying to get relief from the trustee, I hear chocolate shakes go a long way. Am I right? I saw it. Okay. But we were talking yesterday in preparation for this that to our knowledge, nobody has yet that we have seen gone the B2 route, which is seek relief via motion or otherwise in the court. But then again, we wouldn't necessarily know because we don't get entered on the case unless there's some, either some other agency or some other reason we're on the case. We won't enter our appearance until the IRS says, hey, this case is prime for dismissal. So if people are filing motions, we won't know it. So I think we were curious, maybe the judges or their staff know, has anybody gone down the B2 route? Has anybody filed a motion under B2? Shakes of the head. Okay, all right. Well, just know that it's an option. I'm not advocating for it, obviously, because I think our judges are probably busy enough already without more motions on their docket, but it is something in the code that is permissible, and it is something you can look into if you're still, yes.
So does that extend past the, like, let's say we do let them get the continuance, we hold it open 120 days or whatever, does that B2 then allow them to get additional time past 120 days?
I'll rephrase the question and then turn it over to Shane since he's got the statute in front of you. For anybody who didn't hear, the question was, if the trustee under B1 allows in his or her discretion the 341 to be held over for the maximum, I believe 120 days, right? 120 days, can that debtor then seek relief with the court under B2 at the conclusion of the 120 days? Is that essentially your question?
Yes.
What say you, Mr. Blank?
I would say yes. I mean, part 2 says the court may extend the filing period established by the trustee under paragraph 1, 4, and then either 30 days for past due or up to the automatic extension from not past due. So yes, again, potentially. Again, if the trustee says for whatever reason you get, right, it's discretionary. So if not past due, up to 120 days. Trustee says you get 30. I don't know, under the circumstances, that's what they say. And then I'm not giving you more than 30. Well, then potentially you've got relief under part 2 to say, okay, wait, I need more time. And then the court's got that flexibility. So B1 and B2 are really trying to work together in a way for the debtor's bar to have flexibility to get the time you need, but it's not going to be unlimited, and you need to know that going in. A much shorter duration for past due. They're going to expect that if you've got the 2023 and you filed in 2025, you should have a pretty good fix on why it's not been filed, and so you're not going to have nearly as much time. But yes, you can, to answer your question, you can extend it.
Understanding, of course, we're not a party. If you file a motion under 1308 B2, we're not a party to that motion. I don't know that we would necessarily, we wouldn't get notice of it. We're not going to weigh in and assert a position. We're giving you our interpretation of the statute. So take that with a grain of salt, because our interpretations of statutes are not always the court's interpretation of statutes. Love you, judges. But that's our interpretation, is that that's a possible way to go. You, of course, have to, make that motion to the judges and convince the judge, because he or they get to decide that. So we're going to go to a case called Dunlap. The Dunlap decision, I'm guessing that most of you have either heard of it, read it, whatnot. But just by way of background, Dunlap, for better or for worse, was the first post-January 21st or concerning first case that came up for hearing under the new policy. So we said, starting, as I said, every motion filed post 1/1/25, we were going to seek immediate dismissal. Dunlap just happened to be the first one. Dunlap happened also to have one of the most sympathetic, or at least pro-debtor set of facts that you could possibly have, which, from my personal perspective, made me feel like crap, but that's neither here nor there. In this particular case, Dunlap had a missing return. She attempted to file the return on multiple occasions, but butted up against the bureaucracy that is the U.S. government, and was just unable and unsuccessful in getting that return filed, despite her efforts to do so. Once the return was eventually filed post the 1308A1 deadline, it showed that the new liability, because the IRS amended the proof of claim, was something in the neighborhood of $400 and some change. So we're not talking a big tax liability. We're also talking about somebody who's unsophisticated, no offense to her, but who made what appeared to be, at least on paper, an honest-to-God effort to file the returns, just didn't do it by the time the deadline came around. So clearly, some not so desirable facts, at least from my perspective. But as we made clear, we weren't going to discriminate based on facts. We were just going to take a hardline rule. The 1308A deadline is X. If you don't meet X, we're going to seek dismissal, and we're not going to start trying to get into, is this case worthy of it, is this case not, because then that starts down a rabbit hole we're just not willing to do. So this got argued and briefed before Judge Surratt States. Ultimately, Judge Surratt States issued a published decision, found in 669 BR 817, discussing that she has no discretion, that regardless of what the extenuating circumstances may have been that prohibited this particular debtor from being able to timely file those returns. There aren't exceptions built into 1308A. It's just a you did or you didn't kind of statute. And then Congress gave the bankruptcy courts, as Judge Surratt States held, no discretion. Even if they don't like what they're doing, they still have to do it. So that, again, it was not something I went home and felt great about doing, but it was something we had to do because it was our new policy. And at least it demonstrates, at least from our perspective, it demonstrates that we're not picking and choosing. We're not treating some debtors one way and treating other debtors the other way. You can at least know that when we get the referral, regardless of the circumstances, we're applying the policy. What we don't want to have happen is that if we made, right off the bat, we've made an exception to the rule, and everybody would come and say that, my particular client or my particular client's set of facts fits into your new exception that didn't exist in the law. So that, at least that demonstrated that we are applying this across the board uniformly without regards to circumstances. So again, not a fun case, but the holding at least is consistent with the government's view, and we are now using that case, as you can imagine, quite profusely in our pleadings, and will continue to do so.
Which precipitated our change. Understand that, again, 1308A is our mandate. That's Congress is telling us what to do. Congress writes the laws. We go and enforce it. The judges, tell us what the laws mean. 1308 doesn't give us any kind of excuse. It's if it didn't happen, this shall, and that's how we've handled it. 1308B is unique. I don't know how much litigation there is. Go ahead.
So what do you consider file? Is it when it's mailed and when it's accepted?
That's the next slide.
Is that coming up?
That's coming up.
Should have looked ahead.
That's coming up. I'll get there.
Okay.
But just to
Never mind, I'll be patient.
Just to put stop, 1308A is our responsibility. It is non-discretionary and it is not subject to exception. 1308B, I briefly looked at it out of my own curiosity. It's frankly not an argument I would make, but the discretion given to the trustee does not bind it to things like beyond the control of the debtor, which is Part C. So when and how and why the trustee says when, why, how, and to what duration, I don't know. That's a whole new body of law perhaps to be argued. But that ain't gonna be DOJ, right? And so we do A, trustees got B, and C, that's the first time you see Congress adding limits by a preponderance of the evidence, and it has to be beyond the control of the debtor. And again, that's not really if an excuse fits within that, it fits or it does not. So it kind of takes discretion away a little bit too. But interestingly enough, in Congress's wisdom, the most discretion came for 1308B to the trustee. Take that for what you will. To answer your question,
Well,
go ahead.
speaking of Congress discretion or Congress's declaration, I had a gentleman ask me, why are we not applying this as equally in 11 and 12? And the reason is because Congress, for better or for worse, decided that it was going to include these provisions in 13. I can object to confirmation in an 11 based on an unfiled return, and I have good case law that a Chapter 11 plan can't be confirmed when a debtor doesn't file a return. But as Judge Walsh held last year, whereas there's a cutoff date and a statutory deadline in Chapter 13, 11 may have a duty to file, but Congress didn't give us a deadline. I don't know why. So to answer this person's question is, why are we doing this in 13 and not 11 and 12 and I guess 7 and 9, but 9's? It's because Congress put the provision in one and not the other. So it's not, we are not picking on the 13 debtors and 13 debtors bar as much as people may think we're just, singling you guys out. Congress did it. We're enforcing laws by Congress. If you think that Congress should have added a provision into 11 and 12 with a hard, fast cutoff date, they didn't. Somebody can add it at some point, and we'll enforce it just as vigorously in those cases as well.
Okay, so on what does it mean to file? The courts have admitted that it does not specify in the bankruptcy code, and so they look to parallel tax provisions for that. That takes you on a deep dive if you care to do the research. It goes all the way back to a U.S. Supreme Court opinion from 1916 called Lombardo, and it was the physical delivery rule. You have to physically deliver things, hand them to the IRS, physical, and then you satisfy the file rule. Congress, in its wisdom in, I think the 1950s, 54, said, okay, well, wait a minute. We have a thing called the mail. Maybe we should use it. 26 U.S.C. 7502 is passed, and what it does, and that's where we go back to what I was saying with the past due or not past due. What it does is allows you to extend when something is treated as filed with either a postmark or a certified mail receipt. So you can post date back to that. So if it was due, tomorrow, what is tomorrow? The 8th, on the 8th, and you sent it today, and then it doesn't get to them until the 10th or whatever, you get to come back to the 7th and say, I have a postmark. I gave it to the government, granted postal, but I gave it to the government on the 7th. The unique part of 7502, though, and that's where you see with what Congress is talking about in 1308B, 1A, and B, is all 7502 is doing is extending when something is due. So your prior year tax return, potentially, right? You file in January, the tax return's not technically due until mid-April, April 15th, right? And you could maybe argue the postmark thing or whatever. That might be true. But your prior year tax return, 2023, it was past due the April back when. It is past due before you even filed your petition. That's why Congress, 1308B, 1A, for any return that is past due as of the date of the filing of the petition. And then Part B, for any return that is not past due as of the date of the filing of the petition. Congress was envisioning the same thing. They understood what they said in 7502. So my position has been, and I withdrew one case because at the time, I'll be honest, I wasn't sure of the answer. This is the new arguments we're facing, is when does the mailbox rule apply? Standard is physical delivery. 7502 gives you the option of mail and not I'm going to file a personal affidavit that said I did it, or not H&R Block said maybe, kind of, sort of. You need a postmark and you need or a certified mail receipt. That's what you need. If you don't have those, you're going to have a problem. And again, the issue is when I get a referral and it's 2024 and 2023, well, I mailed both of them the day before. Okay, that might work for 2024. It doesn't work for 2023. You have to physically deliver it, and you didn't. So it's really a moot point what 24 is all about. That can trick people up. Sir?
Can we physically deliver these tax returns to your office?
No.
So that we can not litigate all this?
No,
No.
And I'm jumping ahead to another slide, but maybe it makes sense to do it here. Let's do it. The best thing that you can do is get it to the bankruptcy specialist, whoever filed your proof of claim, or the IRS proof of claim rather, right? So their email, I believe, is on the proof of claims.
Yes.
Yeah, I think it is. They have told me, and I this is, if you take anything away from this whole thing, it's this. They have told me that if you wet signature them, get a wet signature on it and email it to them is fine. Email it to them, you're good. There's a practical reason for this. Practically speaking, if the IRS bankruptcy specialist is satisfied, even if the rules aren't perfectly met, if I don't get a referral, I'm not acting. Right? But number two, there's issues where you'll have, hey, I mailed it in, turns out I did it correctly, whatever, but then there's an issue, well, it was rejected because of fraud. My income fluctuated year to year and the IRS flagged it through their automatic system and then it was rejected. Everything like that can be satisfied by getting it to the bankruptcy specialist. I understand that it's federal government writ large, but the bankruptcy specialist section is not the same thing as sending it to the mail as at Kansas City, wherever you guys are sending it. I'll get to your question next. They're not the same. So you mail it, it's in the ether, IRS writ large is dealing with it. You get it to the bankruptcy specialist, they have told me they have ways to push through things that might otherwise get rejected or have issues when sent to them. So really, practically speaking, you email it to them with wet signatures because they need wet signature, not a type S/ whatever digital, when you're gonna email it to them that way. If you do that, you're good. Ma'am.
2 questions. If the IRS has not assigned a bankruptcy specialist, do I send it to the bankruptcy specialist unit with no bankruptcy specialist listed? And number 2, when you say a wet signature, can I email a document with a wet signature that I have PDF'd and sent out to the bankruptcy specialist?
On the first one.
On the first one, so you're talking about before proof of claim is filed? Because if there's a proof of claim, there's somebody
Yes.
assigned.
Yes, before, in some cases, there might not be a proof of claim filed because the IRS has not been notified that there are past due returns, so there's no proof of claim.
Thankfully, it's not going to be all that frequent because the IRS, Eastern District of Missouri IRS prides itself on being incredibly fast in terms of filing personal claim. To give you an example, Judge Walsh's favorite 23andMe case, we were the first ones to file a proof of claim. Yay! And much to the chagrin of several New York lawyers. But if you're in a situation, the unique situation where a proof of claim has not yet been filed, I'm going to ask, to what address, to what email address do you want that sent? I would think that's probably.
I think that's fine. If it's not though, again, utilize 1308B and say, look, I don't think I need a whole lot of time. I got it to them. Maybe there's an issue. I think once we do that once or twice, we'll work that out pretty quick. I think the answer is it's fine. If it's not, hold open the 1308, say, look, I just emailed it to them. They should respond to you in a day or two immediately. And if they say, hey, look, this doesn't work, I need you to tweak it somehow for some reason. Again, if they're happy with you and they feel like you're working with them, they're not gonna send me a referral. So
They don't want to send us referrals. They really
Right.
don't. Because the moment they send us a referral, they have their own tracking that they have to do. They have to bug us every X number of months with emails saying, what's the status of this case? Which annoys the crap out of us. It's an extra burden on them. They don't want to send referrals for your cases, believe me. They just want to get your case to the finish line just like you do. So as much as it's a burden on you guys when we move to dismiss, it's also a burden on the specialists, and they don't want to do that if they don't have to. Yes, sir.
The physical delivery rule, can the debtor deliver it to the, not to you, but to the IRS building that's across the street. Would that suffice?
I dug into that a little bit. I believe the answer is yes.
Yes.
Yes,
So-
you can.
So if they just go down there and say, I'm John Doe, social, blah, 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 sign date,
Yes.
we should be good?
Yes. The reason I hesitate is who that person is and to properly make sure that we're all coordinated. I want to double check that. But yes, I mean, that is the purpose of the rule. So if you
Okay.
have a local office that will accept, and they do, making sure they can properly get it routed to us is an internal problem. But if you argue I did it, and I'm in here saying, no, I mean, that's a really good counter argument to me. Yes, I did. I went down where I'm supposed to. What am I supposed to say, right? So whether it didn't get somewhere properly and the IRS is complaining and send me a referral, my first question to them is gonna be, wait a minute. He's saying he hand delivered it down there, figure it out, and I'm not gonna file it MTD until I get that question answered.
From a logistics standpoint, however, be cognizant of security protocols, because accessibility to government offices is different than what it used to be 10 years ago. For example, if you want to have a meeting with me and you just, unannounced walk into our building, we're going to say politely, get out, because you have to have an appointment with an AUSA or a staffer in the U.S. Attorney's office if you want to come to our building. Not our office. You can come in the building. It's a publicly accessible building. So I'm not sure, like, if you just walk up unannounced without an appointment, I don't know if the IRS security protocols are, whether you have to have an appointment or not. That's something we can look into, or you might want to contact the IRS. And of course, it's a federal building, so you're going to have the fancy ID that gets you into the building anyway. So if you come there and say, but I don't have a real ID driver's license, the U.S. Marshal is going to say, sorry, you can't get in this building to go to the IRS.
I believe
So just check, just make sure your clients are cognizant of the security concerns and appointments and blah, 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 blah.
When these late returns do get filed during the hold open period, then of course the IRS proof of claim is nearly always an estimate, which then leads to the debtor's objection to the estimate, because now the tax return's been filed. Your office, of course, gets a copy of the debtor's objection to the confirmation. Do you want the tax returns as a factual support for the objection, or just the objection?
I would say just the objection. Again, if you give me a tax return, unredacted, you attach it as exhibit and file it publicly because it's got the social security number and first PII redacted, okay, that's different. You give me a tax return that's got a social and other PII, I have to go through 1,000 different things that I don't have time, frankly, to do and have no desire to do. So if you're filing within that 13.0B window because Diana and her staff felt sorry or held it open, and we don't have a referral because why would we? But yet you object because you need to get confirmation and the estimated claim is throwing off feasibility or whatever it is. What we do is we can't act by way of background. We cannot speak on behalf of the IRS without a referral. Every other government agency, you object, I can jump in and start defending them without their knowledge or consent. Of course, I will get that, but I can start defending them immediately. IRS, I can't do that. By law, by statute, the IRS and the IRS only, I have to wait for them to actually communicate to me, please defend our interests before I can legally act. So if you send me an objection that says, hey, I filed within the 13.0B time frame, I object because it's still estimated, I'm going to send the objection to the IRS, and they're going to look at it and say, yeah, we just, it's in the hopper to file an amended POC, just haven't got to it yet. I'll communicate same to you. Or maybe you file the 1308, you file a return in 1308B, and you underreport, not you, but your client underreports by 50,000 or something. They're going to come back and say, yeah, they filed, we're not seeking dismissal, but there's a problem because the 1099s show 100,000 of income and the tax return shows 50,000 of income. There's a problem. But that I don't need a return as evidence of that. I'm going to go to the service. The service is going to tell me what's what.
Self-serving affidavits. Okay, specifically with what it means to file, you run a terrible risk saying, well, my client tells me it would happen and I'm going to file an affidavit saying that it happened. Bedreau is a case from the First Circuit. Is it Woodlawn? There's an Eighth Circuit case. Wood something. What estate? I don't know. There's an Eighth Circuit case that says it's fine. It's not fine. The reason being is the First Circuit looked at all of the available circuits and what's going on, and it turns out there is a Treasury regulation that changed and established what you have to do to prove that filing. And it gives certain abilities, and affidavits are not one of them. I think state law allows it, which is why there's some confusion, but federally it does not. And the First Circuit goes on to say, even under the most lenient rules of some of the district courts in their split, we think it's been resolved by the Treasury regulation change, but even if it hasn't, no court of appeals, I'll read it to you. In fact, the Crook Court noted that, quote, despite the disagreement between the circuits as to the type of proof which may be admitted to prove the date of mailing, no court, none, has relied solely on the uncorroborated testimony of the taxpayer to sustain a finding of timely filing. So affidavits don't work, and I would not suggest them. It is also true, I found a Eastern District of Michigan case that extended that to the debtor's spouse and the tax specialist. And well, my tax specialist said, the easiest way to prove things, if you're gonna do mailing in particular, is to do 7502, get your postmark. If you have a postmark, you're good, but to rely on affidavits is gonna walk you into arguments that I'm gonna at least try to argue. The judges might disagree, but I think Bedreau pretty handily solves all of this. So yes, I would not suggest that. And secondly, I've seen some issues where, again, I don't think the debtor is even intending to mislead, but I had one that, well, I don't have to file taxes because I didn't have income. And it turns out they had gambling income. Oh, I didn't know that was income. Well, it is. And so when we get the wage and income transcript, we can see things like that. And there are all sorts of issues of like, well, I didn't realize that was income. I didn't know this gift wasn't really a gift. Whatever the case may be, the IRS says that's income and you didn't file a tax return. So filing affidavits also saying I don't have to file a tax return is running its own risk. And we dealt with that a little bit this morning. So the takeaway is take a read of Bedreau, but yeah, self-serving affidavits do not work.
All right, let's talk about the practicalities. I will start with a quick story because it came about yesterday morning. I had a referral sent to me last Thursday. Is Brent here? Brent Westbrook? Brent? Ah, dude, come on. I had a referral for one of Brent's cases, and they said we're missing 2324, move dismiss. Okay. I pull out my template. Sorry, judges, I use a template for these. And I was drafting, modifying, get to the last paragraph where I'm indicating the date that the 341 was concluded, because I want to indicate to the judges not only the date that the 341 was first scheduled to be held, because that creates the 1308A1 deadline, but also to demonstrate to the judges, hey, that the 341 has been held and concluded, so therefore we're past the ability to seek relief under 1308B. And I'm on my last paragraph of drafting, and it turns out Brent asked for the 341 to be held open so that he could file his tax returns, or his client could file the tax returns. And one of the trustee attorneys, who shall remain nameless but is sitting with a pink jacket, held that open at the debtor's request. So Brent did exactly what he was supposed to do. Oops, the IRS sent me a referral. And yes, I spent some time drafting it, but whatever. So I got to go back to the IRS and say, hey, this referral was premature. Now, the new deadline is, I think, August 22nd or something like that. If they can't file their tax returns by the time that the trustee's office concludes the 341, we're going to see dismissal. But Brent did exactly what he was supposed to do, which is, oh my gosh, I couldn't meet the 1308A deadline. I better ask the trustee for help. The trustee's office mercifully granted it, and so I'm holding off on filing a dismissal in this case because he did exactly what we were going to do. So how do we avoid us getting referrals? Because like I said, you may not believe me. My goal is not to get your case dismissed. My goal is not to have David Gunn's blood pressure spike every time I see him. My goal is to, focus my energies and attentions on the bigger bankruptcy issues, the bigger cases, or not bigger cases, but the high dollar cases that have more complicated issues rather than just seek dismissal. So the biggest takeaway is talk to the specialists. Every time we get a referral, it comes in a zip file, and it has 7 or 8 different documents at the minimum. One of the documents are notes from the specialist. And the notes from the specialist are going to indicate not only the dates that, or the tax years that are missing, but also every date that insolvency specialist attempted to or did make contact with either the debtor or debtor's counsel or all of the above. And they, by policy, are not going to send us a referral or dismissal without contacting you all first, or contacting your client if they don't know who's representing the debtor. Please do not ignore that contact. The number of times I have read the notes from an insolvency specialist saying, I made contact on XYZ date, never got a phone call back. Or I emailed debtor's counsel on XYZ date, never got a response back. I can't tell you. If I had $1 for each one, I'd be retired by now. Gosh, that sounds nice. Anyway, if you call, take that phone call, or return that phone call, or return that email, and work with the specialist, 99 times out of 100, I don't get a referral. I'm not asking Judge Strauss-Stace, Judge Clare, Judge Walsh to dismiss your case, and we all are happy.
Which again is to foot stomp, even practically speaking, if you're outside of one of the dates, if you're outside of 1308A, if the DOJ is not sent a referral. So if the bankruptcy specialist understands what you're trying to do and they're happy with you, and it turns out, oops, crap, I forgot to hold open the 341, again, get hold of the bankruptcy specialist, because it's bureaucracy. Practically speaking, they don't have the time or resources to put together a referral. If they're like, they're going to get it to me in a couple of days, no big deal. Problem solved. So your bankruptcy specialist, whoever it is your best friend, even if you're a couple days where you maybe don't want to be or shouldn't be. No referral, no action by us.
Shane mentioned this already, but it's worth repeating. If you're in the situation where you're working with a specialist, get a wet, handwritten signature. Do not rely on electronic signatures. The number of times we have seen instances where a return was rejected because everything was fine up until the signature, and the signature was messed up in some way, shape, or form, and it was therefore rejected. The IRS is required by law to reject it for an improper signature, and the 8th Circuit, along with many other circuits, has held that an improper signature on a return means that it's not a return under the tax code, and therefore you have not filed. So if do yourselves a favor, get your clients to actually pick up a pen, blue ink is probably better because the scan's better, and sign the thing rather than try to sign it electronically. You'll just do yourselves a world of favor and avoid headaches by trying to do it in any other fashion. The specialist can get you past hurdles that might otherwise prevent your returns from being processed in a timely fashion. If there are issues with the return, like unreported income or too many dependents, or dependents are claimed on ex-husband and ex-wives on both returns, which no. They can work with you and get that problem solved and get your return processed a lot faster than if you call the hotline or try to email or snail mail the Kansas City or Philadelphia offices. Talk to your specialist. They can work wonders if you communicate with them and work with them. Bottom line, if you keep the specialist happy, that's better for you, because if they don't send us a referral, we don't know about it, we're not seeking dismissal. Keep them happy so that they're not contacting us. Just work with the specialist. So who's got questions?
I've got a question that's been in the back of my mind.
We'll bring it to the front of your mind.
If I have a client and we've had to do an affidavit of no tax returns required, the ones that we just file with the court and then send to the trustee's office. If it turns out that my client is in error will someone notify me before
Before
the
the-
341 is concluded so that I can take care? Okay.
No, unfortunately,
I'm
the IRS is going to put the burden on your client. I get that creating a My ID account with the U.S. government. By the way, side note: if you all have not created a My ID account with the government, it's great because it can translate. It can be used with multiple different agencies, including Social Security and the IRS. But I get that creating a My ID account is burdensome for the less sophisticated because it requires like a 15,000 step authentication process. I can talk. But if you can get your clients to do that and then they get in, the IRS's system is really user friendly. Yes, the IRS can be user friendly, and you can pull up every transcript for X number of years, and you can see immediately, oh gosh, this transcript says X. My client thinks it's Y. There's a problem, and we gotta fix that before the 341 is held.
I would argue just do like a 1040EZ or something. I mean, you put that in front of the client and then they go down like, oh, gambling's income? Turns out it is. For one, it'll prompt them. But for two, you file it. If it's not necessarily correct or, not, if they're lying, that's its own issue. $0, and I know that's not true. That's potentially criminal. Don't do that. Don't do that.
Don't commit crimes.
Don't commit crimes. Not suggesting that. But if they truly believe that, put a 1040EZ together, have them look at it real quick. Oh, yeah, that's all still correct. I never gambled, didn't do that, whatever. It's 0. You can put that on file. It doesn't hurt. And you did file something. The risk is, I made $1 million and I knew it and I lied and it says 0. And now I'm looking and I've got some other agency saying, what the heck? That's a risk. You don't want to do that. But that's, from my experience, has been quite rare. I think there's 1 or 2 that were like, this might be a criminal referral. And beyond that, I don't have any income. I didn't do anything. Okay, take a look. Yep, nope, don't have any of those. Well, 0, here. 1040Z, 0, nothing. It is filed. You might not have to, but at least there's no argument that you did.
But yeah, you go on IRS's system, you can see not only a transcript, you can also see the wage and income transcript. It's just going to tell you everybody that's told the IRS how much your clients have made. Because if your client said I didn't make enough money, and you go to the wage and transcript, and somebody out there sent the 1099 to the IRS and says 50 grand in income, you know that somewhere there's an issue that needs to be solved. But we're not going to, the IRS doesn't have the time and resources to inform you ahead of time. Your clients are going to have to take that affirmative step and check themselves.